Hi, welcome to a Senior Citizens Forum. I'm Janice Wood, your host, and Senior Citizens Forum is found on e360tv.com. And a Senior Citizens Forum is ours for seniors and their families. And it's important when I say families that they know that a lot of the information here can be used for families, but families can also use the information on here to help seniors. And today I have my my friend David Gerson. He and I have been doing business networking for 10 years or so. He's also my personal attorney for my estate planning and my trust. And he and I today are going to talk about why it's so important that you have a estate plan that includes your trust, and what's the difference between the will and a trust, which what most people will say a will and a trust. Uh, Dave is many moons ago has been a lawyer in Chicago for family planning, but over the last 30 years, he's been doing estate planning with probably thousands of people. And a really quick story about Dave, I have referred him to many of my clients, but one of my clients had come back to tell me that when they went to the bank to show them their trust for their bank accounts, they said they never saw something as detailed as what Dave had. He does more than cross his T's. He's very detailed. And the best part about Dave is that he does love to do house calls. And at the end of this broadcast, we will tell you how to get a hold of Dave. Okay, so Dave, how are you today?
I'm doing great. Having a great day. Thanks for asking.
So thank you for coming back on a Senior Citizens Forum. I know it's been a couple years, but the information that you provide is so important.
Thank you.
And I think I think having a estate plan with a trust is the best legacy you can possibly leave your family.
Yeah, it shows clearly that you care because you went the extra step.
So so tell us why you need that
Well,
trust.
you mentioned the difference between a will and a trust in your
Yeah.
introduction, and the difference between a will and a trust is a will is kind of like an e-ticket ride to probate. And probate is something that most people who know anything about probate understand is something to be avoided. Um, and a trust avoids probate. When it's properly crafted and when it's properly implemented, a trust will keep a family and keep the property out of probate. Why is that important? Well, the average probate in Southern California takes about 2 years. That's really hard to tell people, yeah, you're supposed to move through this and get past this and start you're on a new path, but we're going to keep your feet locked into this for about 2 years or longer, and then you can move on. It's
Yeah.
also it's also very expensive. The average cost of probate in Southern California is now 8% of gross value. The word gross is extremely important because what it means is nobody cares what you might owe on property. It's only what it's worth. So if you have a house and the house is worth $800,000, fair market value, but you've got a $500,000 mortgage on it, what's the house worth to you? The net is what you would walk away with in your hand if you sold the house. That's 300,000. The gross doesn't consider that you owe money. The gross value is 800,000. And so 8% of 800,000 is a whole lot different than 8% of 300,000. Either way, it's a lot of money. But when you're talking about, tens and tens of thousands of dollars going to probate expenses, that's crazy. I got better places to put my money. How
Oh,
about you?
absolutely. Okay. Because when you think about it, you still have the mortgage on the house. You still have, whatever your, yeah, equity is that actually belongs to you, but your heirs would have to pay what the exact value is at that time of death.
Yeah, the market value.
The market value at the time of your
And,
death.
and it doesn't make any sense to me if you can avoid it. And
Right.
you can avoid it easily.
I
And
think that, so many people don't realize that.
yeah, I know. They don't teach this in school.
No.
And
But yeah,
and many, many people don't know enough about it to teach their kids. So we have people growing up all over who have never been introduced to the idea of estate planning, of how do you protect yourself, your property, and your family while you're alive as well as after you're gone. And that's what an estate plan does under, you know, the right circumstances. It can protect everything while you're alive as well as after you're gone.
yeah.
Makes a huge difference in how a family moves forward.
Right. I can remember years, and we're talking a long time ago. My father, he didn't really have any property, but he had some other equities, okay? And he did not have a trust. He didn't even have a will, okay? He had nothing. And we ended up having to go to a lawyer. It took, if I remember correctly, a couple of years, and then we had to pay that to the state plus the lawyer's fees.
Yes, yes. And
So,
it can become a real burden. I mean, there are families that have to sell assets to pay for probate. Excuse me, there's a better way to do that.
so when you're talking assets, let's say somebody, the assets from the estate.
Yeah,
Okay,
they'll have to sell real estate to pay something from the probate. They'll have to, it's just crazy.
it's
Just
crazy.
crazy.
Or any of the other values that are in the property.
Yeah,
I mean,
so
because
it does
I
make
know,
sense to me, and that's why I do estate planning because I saw an opportunity to leave families better than I find them.
okay,
My first legal career in Chicago, I was a divorce litigator for 15 years, and um, for well over 30 years here in California, I've been doing estate planning, and that's my atonement. So
okay.
I'm leaving families better than I found them.
Right. Well, one of the things that we're talking more California law here, because we are seen
That's
in
all
many
we're
other
talking
states
about.
and even other countries, I was going to say you need to know what those laws are concerning estate planning for your specific area you live in.
And this is important. For the most part, a properly crafted trust in one state will work in any state in the United States,
Okay.
even Louisiana. And I say that because all of the United States are based on the old common law of England, except Louisiana. Their law is based on the Code Napoleon of France.
The French.
But our trusts work in Louisiana too. They'll work in Texas. They'll work in uh, in New York. They'll work. Actually, a trust properly crafted here will work in any English-speaking country
Okay. Well,
because
that
their civil laws are pretty much derived from the common law of England.
okay. That's really interesting to know. I did not know that.
Well, that's what I'm here to do. I'm here
Right.
to teach.
Well, I'm happy you're here to teach us because I know you and I have talked about this several times. Several times during the year, I hear you get up and talk about this stuff. but it's always interesting to learn something new comes out. Okay.
Absolutely.
Okay. So if I wanted to start with estate planning, so I have a trust, what are the steps am I going to
Okay,
take to do that?
that depends who you talk to. If you talk to me,
Okay.
I will sit down with you and spend, pardon me, spend an hour or so taking you to Trust 101 because you can't make informed decisions for yourself and for your family unless you have information. So, my job is to give you the information that lets you do your job. So, I take you to Trust 101. I teach you the differences between probate and estate planning and trusts. I teach you how estate plans work, excuse me. And that's really important because a trust is one document of an estate plan that contains many documents. Because my job is to protect you against everything I can think of that might endanger your your life, your health, your property, and your family. So let's start with an idea of what is an estate plan. If you don't know what probate is, it's a judicial process where a judge takes control of everything owned by a person who's died and decides what to do with it. And I've already commented on two of the big problems with it. Takes too long, costs too much. Trusts don't take too long and don't cost too much because you're not going to probate court. There should be no need to have lawyers involved in it. It should be easy. It should be simple. It should be direct. If you've got a bunch of people who can't get along on even on what time of day it is, they'll find a way to spend money on lawyers. But the vast majority of people don't need to do that and know better than to do that.
I
Okay?
think I think that's so important. That's why I always look at this. We talked about the probate part of it and what it could cost, but also if you don't have things written out, it's the emotional part of it that your families are going to go through.
Yes.
Yeah. And some families are easy to deal with. They'll deal with it very easily and be fair with each other. But there's other families where they'll fight over something minute
Yes. And for no reason.
and for
It's
no
all,
reason. Yeah.
and
And that
it's
takes that trust takes that away.
the trust can remove all of that from the equation because a good trust is going to have a very important provision in it, and that's called a no contest clause. So you prepare the trust, and it says what you want done with your estate. It says who's going to be responsible for doing it, okay? And how is it going to be distributed?
Okay.
That that means you're going to have individuals involved with responsibilities. There are three classes of people involved in a trust. The first class are called trustors. Those are the people who create the trust, and they have unique power over the trust. The trustors are the only ones who can add or take out of the trust, for example. And more importantly, the trustors are the only people in the universe who can make changes to the trust. Okay? They can change it. No one else can make changes. The second class of people are called trustees. Trustees are the hands on management. Usually, the trustors are also the trustees because they're the ones who are most likely to take the effort to do right by the trust. Okay? They will also be replaced with successor trustees. Successor trustees are the people who step into trustee shoes when the trustor dies. and they become the new management. However, they cannot change a word. They cannot deviate an inch. They have to do exactly and only what the trust tells them to do and how the trust tells them to do it. Okay? The third class are called beneficiaries. And usually, the people who create the trust are the beneficiaries of the trust during their lifetime. And they will appoint successor beneficiaries after they're gone who will participate in the estate. They will participate according to the directions of the trust. You get this much, you get that much, whatever the trust says, and the successor trustee makes it happen. Now, in the trust, there's this no contest provision, and that says any beneficiary or person who thinks they should have been a beneficiary who disputes the validity of the documents or disputes the distribution plan without an extraordinary reason forfeits 100%. They get nothing. If they had something in the trust, they lose it. And they're exposed to other liabilities by virtue of having brought a non-meritorious action. The bottom line is all of the extraordinary reasons, the ones that work, have to do with whether the trust document was a knowing, free, and voluntary act. So if somebody could prove that the trustor was legally incompetent at the time they signed the document, that would be a good reason. If they could prove that the trustor was under duress, was threatened and forced into signing the document, that's a good reason. It's not their free and voluntary act. If they could prove it was the most unfair distribution in the history of the world, that's not a good reason.
I know I had my mother try to do that, contest. It
It's
did
not
not
a good
work.
reason because it's your stuff and you can do what you want with it.
Yeah,
Period.
absolutely. And I
Okay?
remember she going to court. She actually went to court to say
Yeah.
she didn't agree with this, and the judge said, "No, this is not right."
Yeah.
But we're
Yeah.
talking something about 25 years, 30 years ago,
Yeah. Ain't going to work.
and it did not work. Yes.
And then uh, in my trusts, I go into a rather detailed description and definition of incompetency since there's more litigation on that than any other issue in trusts historically.
Mhm.
And so I define it so that there's a lot less to fight about. Clarity is everything. And so um, the trust does all this and spends a lot of pages on trustee powers. Because a trustee can only do what the trust tells them to do, we have to be comprehensive in the grant of authority. And so there's a lot of words that go into that because we're not only granting authority, but we are limiting how things are done. We want a really predictable result. And so we have to be clear. Then we get to the point where people give stuff away. And that's always the fun part.
Yes, it is.
There are two kinds of bequests or gifts. There are gifts prior, which involve gifts of specific things to
Mhm,
specific people, like a mother who leaves her wedding rings to her daughter,
mhm,
okay? Or a father leaves his Rolex to his son, that kind of thing. Or someone who leaves a piano to a musician in the family. Specific items to specific people are gifts prior. Everything else in the estate is called the rest and residue. And that goes to the beneficiaries at large in the fractional shares that the trust sets forth. If you've got three kids, usually they each get a third. But you can say, no, I want this one to get 40% and that one to get 40%, and the one over there gets 20%. It's your book. You design it.
Yeah, because you have different reasons as the
Yeah,
person putting it together.
yes. And when there's a disparity or a disinheritance, I always include reasons because I know if somebody's not liking it, they're going to say, I'm going to court. Well, it's easier to go to court if there's no track record of why that was done. But if you put into the document, this is why I did it,
Right.
they have a hill to climb. So it protects the trust by being more specific. Okay?
I think I because I am in health insurance, okay, and I find that when I go out to my clients, I ask them, I think if it's appropriate, if they have a trust, okay, because I'm looking at who has the medical power of attorney, who can speak for you while you're still alive and decisions need to be made.
Yeah, so it's very important. The thing is, in an estate plan, you'll have a number of different documents that are each legally independently significant.
Mhm.
And so the healthcare power of attorney, what we call an advanced healthcare directive here in California, uh, is one of those documents. If you have an estate plan, that's absolutely a part of it. It's separate from the trust, but it's a part of the estate plan. My estate plans contain 10 sections, and that's one section. Matter of fact, that happens to be section 7. But the point is, this is where you appoint someone to make medical decisions for you only if you cannot make them yourself. And there are a couple of caveats here, a couple of important points. Under California law, a medical power, a directive can go into effect one of two times. The first time is only when your primary physician determines that you need it. And that sounds really good, except it's not really good because it authorizes your physician to have the power to obstruct your agent merely by saying, I'm sorry, she doesn't need you yet. Let's talk in a few days. And so it can effectively obstruct your agent. The other time is immediately. And I have never had a client use anything other than immediately for the time that it goes into effect. Because legally, your agent can't do anything that you disagree with or anything unless you're unable to do it yourself under this power of attorney. And then you get to the question, which is the reason why we have this power of attorney, and that's called end of life. You can choose not to prolong life, or you can choose to prolong life. I think in over 30 years, I've had 4 people choose to prolong life. None of them had a good reason. One was a shocker. Everyone else chose not to prolong life because when you do that, what you're saying, what the document says, is basically if I'm suffering from an irreversible, incurable, fatal condition that will kill me in a relatively short period of time without medical intervention, and I'm not going to have any quality of life, pull the plug. This is critically important, because it's not only a clear expression of your intent, but it relieves your agent of guilt. when I went through this conversation with my kids, I told them very clearly, it's fine if you're on that hot seat. It's fine to feel bad if you have to pull the plug on me. You can't feel guilty about it because it wasn't your decision.
Right.
You had nothing to say about it. I made that decision. I put it in writing, and I tasked you to do it because I was not able to.
And
So
also,
no,
I know from I have some close friends, a close friend whose father passed away a couple years ago, and the mother would not make the decision.
yeah, she couldn't.
She wasn't, I mean, for her husband.
Yeah, she couldn't. She was emotionally not capable of letting go. And that's understandable. But that's where a written document comes in
Right.
with tremendous power and tremendous freedom from guilt.
From and also it put her daughters who knew that where this was going in a very emotional, it was emotional because she would come over here after being in the hospital saying, my mother.
Yeah, yeah.
And
It's,
it was,
it's a really bad place to be
yes,
emotionally, and it's avoidable.
yes.
And so, if we can do something to make our lives easier and to make the lives of our family and friends easier, there's really no reason why you shouldn't do it, and every reason to do it.
Yeah. Well, one of the things that I have from experience, I'm sorry to say, is that I've been in the hospital. And when I have been into the hospital, one of the things they ask for is a copy.
Uh-huh. And if you don't have one, they will give you one.
Yeah,
And it may not be the one that you would want.
right.
For example, uh, every directive I've seen from a medical facility has the primary physician in power. They'll have a little box buried into a paragraph saying, unless I check this box to make it effective immediately, but nobody reads through the whole paragraph. Nobody notices the box. Nobody tells them. And that's the way the medical facility wants it. Okay. I tell my people, because there are three medical documents for any client of mine that has real estate. One is the directive, and the other is a HIPAA release. I have a separate HIPAA release. A lot of people try and mash it together, put a HIPAA paragraph in the power of attorney. I don't believe in shortcuts. The power of attorney is based on state law. HIPAA is based on federal law. They don't have the same mommy. It's one page to print out a HIPAA release. I can do that. So I have a separate HIPAA. This is a document that authorizes your doctor to talk to specific people about your medical condition. Among those are medical providers who are actually serving you in other capacities, your successor trustees on your trust, the agents on your power of attorney for medical care. They're all on this, and the doctor is authorized to talk to them about you and your medical condition. Without it, he's not talking to anybody. Can't.
Yeah, it's real important because I see now when you go to the doctor's office, they always ask you, who are we allowed to talk to? And that's part of HIPAA, which is protecting you from your health information being sold
Yeah,
or shared with other people.
it's really, really, really important. I
Yeah,
can tell you a story, a personal story. My
yeah.
daughter went to the University of Arizona in Tucson, and she got sick when she was there. This was her first year. And she went to the infirmary. And I called and I asked the doctor, I said, what's going on with my daughter? And he said, oh, okay. I can't tell you. I said, I'm her dad. He says, well, I have no doubt in my mind. I can tell. But she's 18 now.
Yeah.
And if you want me to talk to you, she has to sign a HIPAA release. So I asked him, I said, so what's your fax number? He said, why? I said, I'm going to fax one over to you now, have her sign it, call me back. He said, yeah, I can do that. And he did. I faxed him the HIPAA. He had her sign it. He called me back and we spoke.
Yeah.
But without that, he was not
You're
going to
not
talk
allowed
to me.
to do it. Yeah.
He couldn't.
Okay. So, Dave, what are the other sections that are
Okay,
in
good
HIPAA?
question. Everybody, in addition to a trust and in addition to a power of attorney for medical, needs a financial power of attorney. And there's a specific one in California. And the trust governs everything that's in the trust. So this is more outside of the trust. But it authorizes an agent to step into your shoes and handle your personal business if you're unable to do so. So if there are documents that need to be signed that you're not able to sign, your agent can sign them for you. Most important to me is a paragraph in the power of attorney, at least in recent ones, that protects you from the state of California. This is specifically pointed at the state of California's desire to protect its citizens by becoming their conservator. If you don't know what a conservator is, it's a guardian on steroids. And I'll just remind you of the battle between Britney Spears and her father.
Okay.
Her father controlled every penny, every minute of her life, and he was her conservator. The state, if they are your conservator, will put their people in your pocket and control your life. And there's nothing worse. So, a properly crafted financial power of attorney will have a paragraph in it that says basically, if there's any proceeding to have a conservator appointed for me, I nominate my people and I name them. When the state sees that, pretty much they're going to walk away because they are not going to invest time and effort and resources in a cause that they are going to lose. So it can help protect you
Okay.
from the state of California getting at you through conservatorship.
And will that be that way in other states, similar?
I'm confident that other states will have a similar type of document.
Okay. So, what's another section?
Another section, another section is called a certification of trust. A certification of trust is about the trust itself, and it's a summary of the trust designed specifically under California law to verify the existence of a legal trust for companies you're going to invite to do business with your trust, like banks and financial institutions and so forth. And properly drawn, it will contain the 12 elements that the statutes provide for, and it gives absolute credibility to your trust when you tell Charles Schwab, I've got a trust, I want to put my accounts in the name of the trust.
Okay.
They'll take a look at that and they'll have no problem with it. Banks, uh, banks used to just take a photocopy of the section and stick it in your file. About 6, 7 years ago, banks uh, got their own forms, which is essentially the same form, but it's on the bank's letterhead.
Okay.
So the bankers don't think they have to read it. And they'll ask people to fill it out and sign it, when all they should do is spend 20 seconds to take this section, it's 4 pages, take it out, photocopy it, stick it in your folder. I mean, how easy can it get,
Yeah.
right? So that's the other thing. There's another document called your last will and testament. And people always say, why do I have that if I have a trust? I thought the whole idea was to stay out of probate. It's a very peculiar will.
Yeah.
It's called a pour-over will, and it is designed specifically to work with a living trust. And for everyone who has a living trust, it is a safety net. When you get rid of the legal mumbo jumbo, and it's a very short will, what it says is, when I die, if I forgot to put something in my trust, I leave it to my trust.
Okay.
It's a broom to pick up the crumbs. If you follow the directions that you should be given by the attorney who prepares your trust, there will be nothing left out of the trust that belongs in the trust. Okay? Now, for younger families, and my demographic has been moving down dramatically over the past 10, 12 years. And I'm regularly doing estate plans for families in their 40s now, late 30s even. And for families like that, the last will and testament provides an opportunity to nominate a guardian for minor children. In California, guardians can be nominated only in a testamentary document. Now, a trust is implemented the day you sign it. A will is implemented the day you die. So a trust is not testamentary and a will is. So this is where you nominate your guardians. All right? Now, I have another section in my estate plan to make things easier for everybody. That means the people who made the trust and the people who follow after them. This will contain things like an assignment of personal property. I don't want anything left out of my trust. So what this says is everything in my house is in my trust. I don't have to write up an inventory. If it's in the house, it's in the trust. If it's furniture, if it's furnishings, if it's artwork, if it's books, if it's silver or crystal, if it's tools, if it's jewelry, if it's musical instruments, whatever it is, if it's in the house, it's in the trust. Keeps it easy and clean. Cars are different a little bit. They're personal property, but ownership of a motor vehicle is evidenced by a certificate of title. And so I tell my clients, put your car in the name of your trust. Next time you buy a car, buy it in the name of your trust. If you have a car, put it in the name of your trust. If you belong to AAA, they'll facilitate it so you don't even have to go to the DMV. You bring your trust binder in, your registration. They will try to dodge it. You don't have to do that. Tell
So
them
is
you
that the same if you own a boat,
yes.
an airplane, all of that would fall?
Anything, yeah, a mobile home, a
Yeah.
manufactured home. These are evidenced by a certificate of ownership, and there are ways to move those into your trust.
Okay.
And they should be moved into the trust. Okay?
Okay.
My binder contains another section which is kind of my pride and joy. It's called Final Instructions. It's not for the people who make the trust. It's for the people who have to manage the trust after they're gone.
Okay.
So this is a baby step by baby step plain English guide on how to settle a trust estate. And it works. It
It
works.
does. It does because I've experienced what it's like to go through with someone without. I've experienced what it has been for someone with, and this is before I knew Dave. I had my mother didn't want to spend the money to do a trust, and so I talked to my brother and I said, "Let's pay for it because
Yeah.
we're going to be better off in the long run if we pay for it now than pay for it later."
Yeah.
And
Yeah.
she did own property and she did have other assets.
Yeah.
And we found someone, and it was her will and her trust.
Yeah.
And she got to choose what she wanted, but when she died exactly a year later,
I had a
it was the
neighbor.
best thing we ever did because we go to the bank, there was nothing was said. When we took over her property, it was so easy. We didn't have to deal with anything.
Yeah.
And we used that medical affidavit because there was a point where she couldn't speak for herself.
Yeah. It's called planning for a reason.
Right. It is definitely planning for a reason. Yes.
I had a neighbor who stopped me on the street one day. I was walking my dog, and he said, "You trust, don't you?" I said, "Yeah, I do." He said, "I just bought my mother a trust from LegalZoom.
Yeah.
Could you look at it before I have her sign it?" I said, "Sure," because I know what they do. And I brought over a trust binder that I have as an example. And I went through LegalZoom. First, I showed him. I said, "Okay, this is 11 pages." I said, "And here's a trust that's 23 pages. Do you think one of them might have left something out?" He said, "Might appear that way." I said, "Let's go through this and take a look at it." And when we got done showing him what he had and what he should have had, he looked at me and said, "So would you do a trust for my mother?" "I'll pay for it." I said, "I'm glad to hear you'll pay for it. I'll do a trust for your mother. However, she's going to be my client. You're
Mm-hmm.
just the bank. So you don't get a voice, you don't get a vote, and I won't talk to you about it unless your mother tells me to." He said, "Sounds like a lawyer." I said, "It is a lawyer."
You are a
That's
lawyer.
how it goes. And
Yeah.
he put me in touch with his mother, and I went out and saw her, got all the information, and put all her documents together. And we had everything signed at his house. His mother came over, and everybody was there, and they all participated by observing what was going on.
Well,
So they all knew what was happening. Makes a
I
difference.
yeah, I can tell your neighbor that's the best money he spent.
Yes. Yeah.
Yeah. Totally the best money he has ever spent because I know from experience and doing just what he did,
Yeah.
it
And
it saved so much heartache.
it does. It does. I'm delivering a trust next week for someone. Same thing. Mom and dad need a trust. They weren't really interested, but son knows what's involved. He has an estate plan,
Okay.
and he brought his folks over to his house and sat them down and said, "You're going to talk to my lawyer, and we're going to do this. Don't worry about paying for it. I'll pay for it."
Mhm.
And it's nice to see people take advantage of the opportunity to smooth the road forward, because that's what we're doing. We're making this a smooth transition, no drama, no chaos,
It is.
and everything is predictable because everybody knows what's supposed to happen. As a matter of fact, when I deliver a binder to a client, I give them a cheat sheet of stuff that they will forget. And one of the things that I tell them, because I think it's really important, is I want you to make a photocopy of this binder from cover to cover for each one of your successor trustees and each one of your beneficiaries who's old enough to understand what it is. That does a couple of things.
Yeah.
First, it lets them ask questions of you if they have questions while you're alive.
Okay.
Second, it gets a photocopy of the signed and notarized documents offsite. So if there's ever a catastrophic loss that results in all of your documents being lost, we can access the photocopies of signed and notarized documents, and that works. That works. 2 or
So
3 times a year, I get calls from people who have lost their trusts, and they haven't done this, and they have to pay for a replacement. And it just doesn't make sense when you can do it so easily.
yeah, well, I want to say, because you and I live in Southern California,
Yeah.
luckily we're both in areas that have not been affected by fires. How many people have lost those legal documents?
Yeah. Yeah. But if they have it somewhere else, a photocopy,
A photocopy or something in a
a
computer?
photocopy of the signed and notarized documents. If they want to put it on the internet, put it up in the cloud, I don't have a problem with that. Scan it and put it up there after it's signed and notarized. But don't call that your backup. Okay, geeks will tell you one backup is not a backup.
No. Okay.
And when you put documents in the cloud, they're only good if you have a computer, you have power,
Yeah.
you have access to the internet, the documents have not been corrupted over time, and you can pull them down.
Yeah.
So there's a lot of ifs. So if you want to put them in the cloud, I don't have any problem with that. I have my documents in the cloud,
Yeah. No,
but
I
I
have.
have 3 cloud accounts where I store documents.
Okay. I
I
think that's
also
very
back up
smart.
everything to an external hard drive.
Mhm.
Okay. And I back up everything to a flash drive that I carry in my pocket.
Yeah.
Every document I've ever prepared for any client is in my pocket. It's on my hard drive. It's in the cloud. I'm fairly comfortable that I'll have access to documents if I need them and they're not available on my
Mm.
working computer.
Okay. Well, we are going to start running out of time, and
Okay.
I know we have not touched on everything. So at some point in time, I would love to have you back and cover what we didn't touch, like why it's important to review.
Yeah.
We didn't talk about revocable and irrevocable trusts. So there's a lot more that I want to talk about, and we're going to have to table that for the future. But I am going to bring up information now to how do you contact David? Which I think, because he's full of information, he can tell you. I'm sure he has other friends in other parts of the country that would be able to help you, or just to get his advice. So there is his information. I'm also going to put how to contact me up here.
And another thing, for anybody out there who has questions, when you get a question in your mind, please write it down immediately. This is like a foreign language, and it'll fall out of your mind while you're looking up the phone number. So write it down and then contact me, and I'll be able to address your questions.
And one of the things, you spend a lot of time researching different things, but people don't research. There's certain things that aren't researched that are so important to our lives. And this is one, is
Yeah,
how to protect yourself, how to give your family a living legacy
yes,
and a memory.
it's all key. It's all key. And there's really no reason not to do it. I frequently have people who ask me, well, what's the downside to having a trust? And I tell them, I've only been doing it for over 30 years. I haven't discovered one yet.
Okay.
Who knows? Maybe in 100 years I'll discover something. But so far, nothing negative about trusts. They
Okay.
are really, really an important tool.
I'm definitely going to invite you back onto the Senior Citizen Forum. But thank you so much for being with us today. It's been great information. I always learn something new from you each time we talk. And thank you everyone for watching a Senior Citizens Forum. And please come back next week where we'll have another interesting topic. Thank you.
Thank you for having me.
Thank you.
Bye bye now.